And further, in the full knowledge that the industrial action which had been threatened in the notice to which we refer constituted an unprotected strike, beginning on the 4th of November, the respondent and its members proceeded on strike, withheld their labor, and effectively grounded the operations of the applicant. That strike continues unabated to date, Your Ladyship. And for that reason, by an application dated the 6th November, and which was placed before you yesterday, 7th November, we commenced contempt of court proceedings on behalf of the applicant. Your Ladyship, being satisfied with the urgency of the matter, issued an order requiring (11) named individuals to appear in court before you this morning to show cause why they should not be punished for contempt of court. And so this morning, Your Ladyship, we are before you for the purpose of those named individuals who are the officials of the respondent to show cause why they should not be punished for contempt of court. Your Ladyship, I see that they have turned out in full force this morning, and perhaps it is appropriate for the named individuals to identify themselves because they are the ones required to show cause. I haven't finished.
Yes, sir.
Yes, let me add, lastly, Your Ladyship, that the order requiring the contemners to appear this morning and show cause why they should not be punished for contempt of court was served in the same way as the order of injunction, which was issued on 31st October 2022. That's all for now.
Thank you. Mr. Who wants to address the court now?
Kimani, my lady.
Mr. Kimani?
Yes, my lady, in the first instance, we came on record yesterday. We were instructed in the afternoon, and we filed a notice of appointment.
Record Kimani Kiabi.
Yes.
So all the three of you are
We have a copy. Yes, we
Kimani
have.
Kiabi.
Yes, we have. And my lady, the order that senior counsel has cited was served at 4:40 p.m. in the evening. And my lady, we have made effort to
It was served at
4:40 p.m. in the evening. In fact, my lady, at that time, both the parties were involved in discussions, but we have made effort to round up and bring named members in deference to the court. My lady, concerning the order, we have two preliminary points that we want to raise. Perhaps before the court can give directions on the study of the substantive application.
concerning the order of this.
Yes, concerning that order, my lady. We have gone through it and we have to want to raise.
Number two.
Yes, yes, my lady. And I'll ask my colleague, Mr. Nairobi, to address you on that specific, those two preliminary points before we can proceed.
If it may please you, my lady, as introduced by my learned senior, my name is Levi Munyeri, part
Levi?
of Levi Munyeri,
Not karaoke.
Levi Karaoke Munyeri.
So we go by karaoke or Munye.
My lady, you can use both names. My lady, I stand on a preliminary issue, 2 in number. My lady, the second one is dependent on the outcome of the first one. And I'm therefore obliged to argue the first application first. My lady, I bring to the attention of the court of the defectiveness and error on the face of the court record, being the court orders dated 7th November 2022. My lady, the orders are in pursuit of the petitioner's application for contempt that is dated the 6th of November 2022. My lady, the orders seek to hold the officials of the respondent in contempt of this court for failure to comply with the court orders of 31st October 2022. My lady, the application...
Just a minute. Yes.
The application was served via the official email of the respondent at 4:40 p.m. yesterday, the 7th of November 2022, while actually the officials were embroiled in negotiations towards an amicable settlement of this labor dispute at the NSSF building in the Ministry of Labor. My lady, contempt of court orders are very specific. The rules and regulations by the court in terms of jurisprudential trajectory are well settled. My lady, by the admission of my senior colleague, these orders were not served specifically to the individual pilot officials that are being sought for contempt of this court. My lady, specific service to specific individuals cited for contempt of court is of critical nature to such proceedings. And my lady, the error to do that is manifest before you today. My lady, one of the persons cited, Madam Christine, my lady, I'm looking for her precise name. Christine Karaoke is actually an office administrator in the office of the respondent, performing purely administrative roles, and hence is incapable of enforcing a court order that requires the indulgence of elected officials. And to that end, my lady, among the list that is before you today, and for want of individual service, a wrong person has been cited for contempt. My lady, that matter being preliminary, I return to the limb of my application of effectiveness on the face of the orders of the 7th of November 2022. My lady, the application that was filed before you seeks 3 substantial orders, 4 in number, my lady. The first one is that the matter be certified as urgent. The court proceeded and did that. The second order that the petitioner is seeking, my lady, is substantive in nature, in the sense that, my lady, for it to be granted the natural right to be heard that is bestowed on the intended persons should actually be granted. My lady, we submit before this court that it was in line with the rights to natural justice and the right to be heard under the Constitution, Article 50, my lady, that the above named officials ought to have been granted a chance to file substantive replies to this notice of motion application through their respective counsel before the court can proceed and issue an order number 3, which actually is to the point that they are already in contempt of this court. And they're actually coming here to show cause why they should not be punished. Consequently, my lady, save for the possibility that it could be an error in the extraction of these orders by the petitioner, the orders essentially are in error on the face of it, my lady, for seeking that the respondent officials actually served with the orders, my lady, presumably, so that they can enter appearance, appoint advocates of their choices. My lady, in such sui generis proceedings, every member that is cited for contempt has a right to seek specific representation. And my lady, the court proceeding and holding them in contempt is tantamount to a gross denial of their natural right to be heard. And my lady, for that error on the face of the orders dated 7th November 2022, which we believe might be inadvertent or an error in extraction of the same, my lady, we pray before this court this morning that the individual officials of the respondent are granted sufficient time to appoint advocates of their choices for purposes of opposing the application to hold them in contempt. My lady, specifically for official number 11, she should get an opportunity to bring before this court the requisite documents indicating that she is an administrator in the office of the respondent and therefore incapable of enforcing court orders. My lady, without laboring the point, we pray before this court that the individual officials cited for contempt be given 7 days, my lady, to individually file responses as to why the non-compliance with the court order, my lady, is not deliberate, is not willful, my lady. My lady, for someone to be held in contempt, it is settled law that he or she did not only disobey the court orders, but that disobedience was willful and deliberate. My lady, to that end, we beseech this court that behooves it grants 7 days for the officials to file their specific responses to the application for contempt. And my lady, within the 7 days, myself or ourselves being instructed by CALPA, the court can be gracious enough to grant us equal amount of time to file responses to the application by the petitioner that cumulated to the orders of the 31st of October 2022. We humbly pray, my Lord.
We will be having another application, but I believe it is right for my colleague to respond to. We will be having another application.
Okay.
Yes, Yes, but
Perhaps they should just finish
Yeah.
everything they have to say, then we can respond
Yeah,
in
and
full.
we
yes.
respond to
My
everything.
lady, it is not in doubt that.
So that is Mr. Kiani
Kimani,
now.
But it's not in doubt in our minds and everybody in this courtroom that the nature of the dispute is one that is critical to the nation, to the economy, and to all sectors of society. And the respondents, my lady, are also very much aware that the withdrawal of their labor has far-reaching effects. My lady, for that matter, since the industrial action commenced on Saturday, there has been many meetings that have been held between the respondents and even the petitioner. The very first meeting was moderated by the Central Organization of Trade Unions, that is COTU. That was the first meeting that was held between the two parties to try and come to an understanding. My lady, there has been a meeting chaired by the Permanent Secretary, awaiting confirmation in the Ministry of Labor. There has been a meeting held between the parties by the Permanent Secretary, by the Cabinet Secretary himself, in the Ministry of Transport. There has been a meeting as late as last night. In fact, the meeting ended last midnight, chaired by the Commissioner of Labor in the Ministry of Labor. There have been overtures from various players in the industrial sector, the Federation of Kenya Employers, and many other players. As we are in court this morning, the parties have been required to attend a meeting at Parliament. This morning the meeting was slated for 10 before the department, before the committee on transport and related matters. So that even as we argue the legal points concerning this dispute, a lot of ground has been covered by the parties. My lady, I can confirm to you that the respondent has drafted and circulated its own proposal on a formula to return to work. That proposal has been received by the petitioner, the airline. My lady, the airline has responded to those proposals, and from our review of the same, despite our appointment last night, my lady, in broad strokes, I could say it covers almost 70% of the issues in dispute.
Just a minute.
Yes, my lady.
I want to hear that one. You're saying
Yes, there are proposals from yes, both sides, yes, and they've been exchanged, yes.
And you feel the airline has not responded?
No, they have responded. They have given their counter proposals, and that have been reviewed by the respondents. And I am saying from our own review of that, almost 70% of the issues are fairly agreed upon. So that, my lady, these court orders and the summons were served right at the point where the parties had reached quite a good momentum as of yesterday to be able to reach an amicable settlement. My lady, in that background, therefore, it is our instructions to apply before the court that what has been missing is a structured discussion between the parties in terms of the framework provided by the law. By having formal mediation in the matter, therefore our application this morning is that the court very kindly does direct that this matter proceeds for court-annexed mediation. My lady, we feel this will be a win-win situation for both sides. And my lady, the court-appointed mediator would be directed on the timeline so that the matter can be sorted at the very earliest. And my lady, on that very point of in support of that application, may I highlight that, my lady, we have received the respondent has received letters of parties of goodwill who are willing to mediate in this matter, in writing, my lady, from one, the Law Society of Kenya, number two, my lady, from KOTU itself, number three, from the Federation of Kenyan Employers, number four, from the Office of the Ombudsman, number five, from the Institute of Human Resource Managers, and maybe lastly, the matter is being handled also by the government through the parliamentary committee. So, my lady, in sum, it is our very humble view as council freshly appointed on record. Yes, we are willing to respond to both applications by senior council, the substantive one of that first, the second application of yesterday. We will respond appropriately to the application for contempt. But my lady, we take the view that that should not torpedo the negotiations at an advanced stage. So, my lady, we are asking, by way of a third prayer this morning, that the court does direct that this matter becomes a subject of a court annexed and court supervised mediation, to which the respondents are willing to fully participate for the earliest resolution of the dispute. Thank you, my lady.
Thank you. I think Mr. Ohaga, Councillor, you're ready to respond.
Yes, certainly.
I assume you're done, or you want?
Yes, but that is fairly our forte. We are requested for time to respond in form of writing.
Okay.
Your Ladyship, I'm a little confused. On the one hand, co-counsel attacks our application. Misadvisedly, I must add. On the other hand, counsel seeks the court's indulgence. However, I have not had any of the two counsel propose that they will purge the contempt, because we are here about the integrity of the administration of justice. It is no longer about the merits of the dispute between the two parties. But let me start with Mr. Munyeri's objections, which I understood to be preliminary objections. Your Ladyship, the objection, as I understand it, is that there has been no personal service of the order. Let us be clear, Your Ladyship, that the order that the respondent is in breach of is the one of 31st October 2022, not the one of 7th November. So let's be clear about the order. Let us also be clear about the state of the law. And we will provide you with this authority, Your Ladyship, in Kiru Tea Factory Company Limited, versus Stephen Minor Githiga and 14 others. This is cited as 2019 EKLR, the Court of Appeal had this to say. The law has changed, and as it stands today, knowledge supersedes personal service. Where a party clearly acts and shows that he had knowledge of a court order, the strict requirement that personal service must be proved is rendered unnecessary. The court went on to say, the notice of the order is satisfied if the person or his agent can be said to either have been present when the judgment or order was given or made, or was notified of its terms by telephone, email, or otherwise. Therefore, the short answer to Mr. Munyeri's preliminary objection is that it is redundant. There has been no error, there is no defect. Indeed, Your Ladyship, the effectiveness of these modes of service today is self-evident when you look behind you. And see that all the members or majority of the members of the respondent are here. We do not claim to have served each one of them individually, but they are aware of these court proceedings. And they were aware of the order on the 4th of November when they commenced this strike. Mr. Munyeri has pointed to one individual whom he says is a secretary. We are happy to strike her out purely on counsel's say so. We'll take that in good faith. There are 10 others he has made no mention of. So, Your Ladyship, we would urge that you dismiss the first point of preliminary objection because it has no substance. As we understand it, the second point constitutes the suggestion that the dictates of natural justice have somehow been overlooked or trampled upon. Nothing can be further from the truth, Your Ladyship. The court has not yet condemned these individuals or found them to be in contempt of court. The court, in full compliance with Article 50, has summoned them to court. That is natural justice. Has asked them to come and explain why they should not be punished for disobeying the orders issued by this court on the 31st October. It is our submission, Your Ladyship, that this court is proceeding in an orderly fashion, having full regard to the necessity to safeguard the rights of the cited individuals. Now, Mr. Munyeri has then asked for time to respond formally to the application. But Mr. Kimani has asked you to send the matter to court-annexed mediation. Now, I'm not sure what they want. But the one thing, Your Ladyship, that is clear in my mind, and that is clear in law, is that whichever route the respondents take, they must comply with the order of 31st October 2020. A party cannot at once be in breach of an order of court and at the same time seek to activate an alternative dispute resolution mechanism. Your Ladyship, I myself a proponent of mediation. But we cannot go to mediation in the present state of affairs. Your Lordship, the application that was placed before you yesterday is replete It is replete with evidence of the attempts made by Kotu, attempts made by the Minister for Transport, attempts made by the Minister for Labor, indeed, when you look at page 111 to 113, you will see a press release by the Ministry of Labor and Social Protection. Which, Your Ladyship, chronicles the attempts that have been made and the frustration that these officers have experienced in trying to resolve this matter. That is not to say that the door is closed, because there is clearly a dispute, and the dispute must be resolved one way or the other. But pending the resolution of that dispute, Your Lordship, the order of 31st October must be complied. We ask that you so order.
Okay, you want to respond?
My lady, if you may permit me,
How many minutes?
I'll take 2 minutes of the court's time to do a quick rejoinder to the able submissions of my learned senior. My lady, the court has been informed of our entering on record in this matter being yesterday evening. My lord, because of unavoidable circumstances on the end of the officials of the respondent. My lady, all we are beseeching this court this morning is that the officials of the respondent be granted a chance to be heard. My lady, the notice of motion before you was filed by a learned counsel. My lady, the officials, none of them is an advocate. My lady, drawing inspiration from Article 50 of the Constitution. And my lady, the nature of contempt being quasi-criminal in nature. My lady, the least this court can do to dispense justice this morning, my lady, is to allow the officials to retreat with the council of their choices so that they can properly brief them to file individual responses as to why they committed a sacrilegious omission of failing to comply with the court orders. My lady, they have a litany of reasons that should be crystallized according to the law and filed before this court in written. My lady, that's my quick rejoinder this morning. My lady, we're in the process of drafting the responses, at least for the respondent itself. And my lady, with the gravity of this matter, we beseech the court to exercise Solomonic wisdom and allow the two applications of the respondent. My lady, I'll cite a case, my lady, that this court is familiar with. My lady, that's cause 2486 of 2016 before this court. 2486, my lady, of 2016. A case where officials of the Kenya Medical Practitioners and Dentists Union were convicted by this court after weeks of canvassing of an application for contempt. And the results were a stalemate of negotiations and a protracted dispute that cost the lives of Kenyans. My lady, the officials of the respondent have reasons why they could not comply with the court orders. Allow them to canvass them. They cannot comply as of now, my lady, for various reasons. My lady, if you send them to jail, negotiations will collapse and the dispute will be protracted to the suffering of nations. We humbly pray that the respondent's application be allowed. Much obliged.
You are praying for which application?
My lady, the two applications. The first one, my lady, the vacation of the orders dated the 7th of November 2022 to allow the parties time to reply within 7 days, my lady. And the second application by my learned senior, Mr. Kimani, that the court grant orders to the effect of a substantive resolution of this dispute through alternative dispute resolution mechanism. That's all, my lady.
We are done?
I think we are done. Everybody has spoken their day. Can I see the contemners? I just want to see them. Can they come? Please. I'm not jailing you right now. Just come. Just want to see you. I've been seeing you on TV.
Before I might add, why is it?
Yes.
I was a mediator in the doctor's strike, so I was frontline seat as to what the ceremony said.
Okay. So I'm trying to see the names of these people. Where are the names? So we have Captain Timothy Joroge. Who is Captain Timothy Joroge is the chair. David Magwa is the vice. And Moredi Nyaga, Captain Moredi Nyaga, CEO. Yes, I've been seeing you a lot. Waraka is that one. We have Wilson Matthew. We have Moredi Ireri. Okay. Matthew Kareni. Joseph Migwe. Evelyn. Captain Evelyn. Daniel Gaita. And of course, Christine. Christine is there. All right. She's not a captain. Right. So I have listened to all the submissions by all the sides very well. We still have a court order which was expiring today. I think you can see it. I just wanted to see who you are. Thank you. Which was expiring today, which has not been obeyed by the 388. Are they 388 pilots? I don't know if some went back to work. The media was reporting some reported back. So how many are not reporting out of the 388? Do you know?
My lady, a majority are here.
Okay. I have listened to this. I can retreat and come up with a ruling. But I'll put my biro down and ask, especially since the pilots are here. If we give you 7 days to respond, what is going to happen to your organization? I can give you 7 days. It's your right, right? To respond. In the meantime, Kenya, that place is still grounded. So I'm just, somebody asked for Solomonic wisdom. I'm trying to get it and find what's the best under the circumstances as senior council. Because we are stranded, all of us. Nobody can travel in or out with KQ. So if we give you another 7 days, they're counting how many losses per day? 300 million is a week. So divide that by 7. So I just would have preferred that I don't take you to jail, because I hear what you're saying. Even if you go to jail, it's not a solution. It's not a solution right now. It is a law, and I have not made the determination. I'm going to go back to my office and make the determination. But I'm telling you to think. As we take you for mediation, or I give you time to hear the case and I close everything else in my office and listen to you within 2 days, and then make a judgment or a determination, can we obey the court order in the meantime and go back to work?
Maybe it is your view that as of yesterday...
I'm talking now as a Kenyan, yes, leave alone even as a judge. Yes.
Perhaps, I don't know, out of my mind, if we can give another 2 more days, because there have been various consultations. We believe that
within the 2 more days, Mr. Kerry, is it to come back to court? Is it to go for mediation? Because this gentleman, with your advice and also the advice of senior counsel to his client, you can come up with a solution as we write. And I know there is a judgment pending before one of my sister judges, right, concerning the same matter. I am not sure when it's supposed to be delivered, but I do know it's pending.
Just say why there is a statement. To me, there is a key point.
Yes.
The two parties have not sat across each other on a table. These consultations are shuttle diplomacy. I believe we could have a chance where both parties sit in a boardroom across each other. That has been the missing link, because the airline has not acceded to coming and facing, you know,
That's
the
not
virus.
correct.
Not in
Yeah,
fact,
I
your
read
framework
the
and
affidavit of Mr. Is it Shibos or Shibos? And it had explained a lot about like, what had been going on. Even if I give those 2 days, there's still a lot of losses to all of us as a nation. There's still a lot of losses. We can meet with you, I think 5 or 6. Can we meet briefly?
Can the media and everybody else be frozen for now? I want us to meet with these people in my office briefly, and then we'll get back to you.